Welcome all. Today is 7th of September 2022 and we are discussing an issue of on the question whether society can refuse a transfer of flat because a document of transfer or an agreement for sale is unregistered. I caution everyone to not to use this video or the information flatly because application of law depends upon basically on facts of the case. So apply if the facts of the case are the same or identical, or it may be partially applicable or it may not be applicable at all. So now question is there, can unregistered document society can refuse to admit the flat purchaser as a member. Now let us go reverse. In Mumbai, in Maharashtra, an act was enacted, Maharashtra Ownership Flats Act 1963. In this there is a provision even today, section 7, where once the flat purchaser and the promoter builder has entered into an agreement and a token is given, then builder cannot change the plan or alter the plan unless there is a consent of the flat purchaser. In the year 1985 and 86, one landmark matter came up before the court. It started from City Civil Court to High Court, and this matter was of Kalpita Enclave versus Kiran Builders. There was an amendment made by the builder in this case, and which was challenged by the flat purchaser. Two flat purchasers' agreement were unregistered and it was highly contested. But then ultimately the amendment of plan was rejected and there was a stay granted. Now going further, subsequent to this MOFA judgment in the matter of Kalpita Enclave, section 4 of MOFA was amended, and in which if unregistered document is there, then a person can go to registrar's office, submit the document, and if the builder doesn't come, it will be registered. There is a provision in section 4, and one more section was inserted. It is section 4A. Now how it reads? 4A reads as, where an agreement for sale entered into under subsection 1 of section 4, whether entered into before or after the commencement of Maharashtra Ownership Flats Regulation of Promotion and Construction, Registration, Sale, Management and Transfer, Amendment and Validating Provisions Act 1983, remains unregistered for any reason, then notwithstanding anything required to contain in any law for the time being in force or in any other judgment, decree, be order of any court, it may be received as an evidence of a contract in a suit registered for specific performance under Chapter 2 of the Specific Relief Act 1963, or as an evidence part performance of a contract for the purpose of Section 53A of the Transfer of Property Act 1882, or as the evidence of any collateral under the said provisions of Transfer of Property Act 1882 and transactions not required to be affected by the instrument. Now moving further, subsequently Maharashtra Textiles and Cooperation Ministry came out with a circular dated 16th of October 1991 not to effect any transfer by the society till the stamp duty and registration charges are paid. However, unregistered document is not invalid and can be received in evidence under section 4A of MOFA Act 1963. So rights under the unregistered agreement stays because there is a consideration which has been passed from one party to the another. The market value, then came the market value concept, and the property document were valued as per the I have stated in the agreement that I have purchased this flat for 1 lakh, for an example. But the circle rates are decided by the government, and if under the that circle rate your property is valued at 1.50, then you have to pay stamp duty on 1,50,000. This is, I am giving you an example. This market value concept came into force from 1st of January 1986, and all the prior documents up to 31st December 1985 are not covered under this concept of market value, and they are out of purview of the concept of market value or the principles of market value. Now, in conclusion, what I say is, in current times, as on today, it is mandatory to pay the stamp duty and the registration charges, and the society is also bound to ask for registered document, stamp duty is duly paid, and they have to verify that whether documents are in order. Now, but the old documents, say of 71, 73, 74, 75, there was nothing as such, because land was not so expensive, neither the flats were so expensive. So they are on 5 rupees stamp paper, printed by the builder, and it is duly signed by both the parties. There was nothing like registration, and it was not a concept known so much within the the common citizens, because there was not even concept of loan on your flat. So it came very later stage. So banks started giving finance for purchasing flat and the house. So in olden times it was nothing like that, and therefore the price of property was under control, or it was undervalued or had no value. You can say in those days people were just giving away the flat. Okay, you stay here, and whenever you feel like, you give it back to me. This was the case, because there was no market value concept. Now documents which are executed, as I said, up to 31st December 1985 are not liable for market value. Even documents prior to 1986 and subsequent, which is unregistered, are not invalidated by their non-registration. I hope the question is clarified by me, and do write your reviews and views on my this short live coverage.